Right, good evening everyone. Apologies to those watching on YouTube for the slightly late start. Welcome to this Cheltenham Borough Council Licensing Subcommittee, which is being held today, Monday the 18th of December 2023. My name is Councillor Dr David Willingham and I'm Chair of the Committee. The meeting is being streamed live to our YouTube channel and is being recorded for training purposes. If there are any breaks in the YouTube transmission, then the meeting will be adjourned for a short period until any technical issues are resolved. For those watching, a number of speakers in favour of the application have requested not to be filmed, so for those watching, there will only be audio during that part of the hearing. Recording of the meeting will be held on the Council's YouTube channel for 4 years. Please be aware that CCTV and audio recording is now in operation, and the footage and recording of that for the Council Chamber will be held for 5 months. A fire alarm is not planned, but if an alarm does sound, then please follow officers and leave via the nearest exit, which are signed with the green signs, so at the top for the public gallery and the 2 doors for the Council Chamber. If you have a mobile phone or another electronic device that makes pinging sounds, could you please put it on silent now so that it doesn't disturb the meeting? As I said, I'm Councillor Dr David Willingham. To my right, I have our licensing officer, to the left, legal officer and democratic services. There are also the 4 other councillors, Councillor Seacombe, Councillor Boys, Councillor Wheeler and Councillor Sankey, just so that you can at least see who we all are. With that, I will move on to agenda item number 1, which is apologies for absence. Since there are 5 of us, there are no apologies. Agenda item 2 is declarations of interest. Does anyone have any declarations of interest? So I just need to put it on record that following a request from someone who I believe is here as an objector, we held a meeting at the council offices to discuss generalities and not this specific application. I now move on to agenda item 3, which is an application for variation to an existing renewal and variation to an existing sexual entertainment venue licence. So because this is a regulatory item, members must be present and have heard the proceedings in their entirety to vote on the item. We will ensure that the applicant and the applicant's representative, if they have one, are in the meeting and present. I will ask the licensing officer to introduce the report. Members will get an opportunity to ask the licensing officer questions about anything in the report. The applicant and their representative will get an opportunity to ask the licensing officer questions, and objectors will also get an opportunity to ask questions if there are any points of clarification. We'll give each objector the opportunity to speak. We will ask you to limit that to no more than 10 minutes. There may then be questions to you from the committee. The applicant will then be given an opportunity to present their application. In the interest of equity, they'll get the same combined amount of time as the objectors have taken. Again, there'll be the opportunity to ask questions. We've now got a new constitution which will allow a further to go round of that loop, and also questions through the chair, so there is no cross-examination. We will allow a spokesperson on behalf of the objectors to sum up, and the applicant gets their final right of reply. We will then debate the matter. There is an option for us to do that in camera, as it were, but we will try and do that in the open if we can, and then we will come back and provide the our decision. So, with that, where are we? There are 10 speakers for the item. There's possibly more now because of 2 councillors have turned up who, at my discretion, we will allow to speak, even though they didn't register. The solicitor, on behalf of the applicant, Mr Burrows, 4 objectors, now 6, 1 in favour and we will reference people by the number of their objection, so that people's names are not in the public domain. So if I can now invite the licensing officer to introduce the report, please.
Thank you, Chair. As has already been mentioned, this is an application for a renewal, effectively, and a variation to an existing sexual entertainment venue licence made by Red Apple Associates Limited for the venue at Cambray Place. The report details what relevant entertainment is, and most of the parties, I think, are aware from previous hearings what that entertainment type is. It's described in the report. The current licence runs from the 7th of February 2023 to February 2024, and this is, as I've said, is a renewal of that licence. The existing days and hours for relevant entertainment to be provided are contained in Annex 1 of the report, as is the hours and days that are being applied for. The application is effectively to request that relevant entertainment may be provided at all horse racing meetings, or in Cheltenham, I should say, during all race meetings throughout the racing calendar at Cheltenham. There's quite a lot of detail in the report, and obviously I won't go through all of that. This legislation allows that there are certain things that should be done in terms of a consultation process, and the council has tried to ensure that those things have been done. So there was notices that were placed at the venue, and there was also a notice that was placed in the local newspaper. In addition to that, the council has previously agreed that it would notify Grassac of applications of an SEV involving an SEV, and we've also agreed to do the same for the bid. Those two groups, obviously, one can be seen as promoting and assisting women and young girls and their safety, and the other group, the bid, is obviously a representative body for local businesses in Cheltenham, and is a consultee on many applications that we see. We have been asked to, this isn't in the report, but we have been asked to notify other groups and individuals. We will not be going beyond what we've already agreed to be doing. We think that's fair and reasonable in the case of these types of applications, which can, produce quite a lot of interest, but we will not be going beyond in terms of notifying any further bodies or persons who may support these applications or maybe be against them. And it should be noted we've had requests from persons against the application, but also from persons in support of the application, and there has to be a line that's drawn, and we've drawn that. As has been mentioned, obligations cannot be made on moral grounds, and we have either the mandatory or the discretionary grounds for refusal, and those are laid out in the report. The police have not raised any concern or objection in relation to the application, and we've received 36 objections and 50 emails or letters of support, both from residents and other groups. Those are all attached to Annex 2 and are clearly labelled as letters of support or letters of objection. There is no discretion for the council to extend the time period which we have for the consultation period, and so any representations that may have been received after those dates are not included. The council does have a policy in respect of SEVs, and relevant elements of that are included and referred to in the report. In some cases, it repeats some of the information that's already in the statutory guidance, or I should say in the guidance or in the legislation itself. We do have mandatory grounds for refusal, which are shown, and we have discretionary grounds for refusal, which is shown on page 8 of the report. Some of the issues that are given consideration are things such as the location of the premises, which is detailed in 4.6 to 4.9. We talk about properties with sensitive uses or in sensitive locations, which is 4.10, and obviously there are references in relation to some of those issues in the case of some of the objections, and members will be, I'm sure, more aware will be aware of that. We've got a section in relation to objections. We refer to the national guidance, which was produced some years ago. There's the meaning of a sexual entertainment venue, in case anyone's not too sure on what that might mean. We also go into some detail about what may happen if we refuse a licence, and not finally, but almost finally, there's a large section on the public sector equality duty. And as is referenced in the report, when this application was first considered, this was prior to a fairly high-profile High Court case, which talked about policy. And I think we all have to remember that the case that's referred to in the report is about policy setting. There are some lessons to be learned from that, and there are some things that we may see courts expecting councils to be considering in respect of that, but we do need to bear in mind that's about council's policy setting, and this is obviously an application. The report does go on at length about what the public sector equality duty looks like, and it is obviously something that the council has to follow and has to have regard to when it makes pretty much any decision or in how it acts. And as I said, there's some guidance that some of which is helpful for all parties and for the members in considering this case. The committee is reminded that the authority does not make a moral stand in relation to the operation of this type of entertainment, and it is for the council to consider this application in the context of what the legislation allows it to do. As has been already discussed in previous applications, there is a balancing act for the council in that although there is the ability for an applicant to apply for relevant entertainment to be provided at a venue, there is also scope for a business operator or an individual to provide relevant entertainment on an infrequent basis. So where an application, or if an application would be to be refused, there is still the possibility for relevant entertainment to be provided in Cheltenham or anywhere else in the country through the exemption route, which allows a venue to provide this entertainment for a 24-hour period, basically once a month. So there is the ability for this type of entertainment to be provided in Cheltenham in any event, which would not be regulated to the same extent as a licensed activity would be. There was an error in the report which I amended partially, but unfortunately I missed out 7.5, which has probably been noticed by others. This venue is within the council's designated permitted area. The council has agreed that there is an area of Cheltenham Borough Council, mainly in the central part of town, where SEVs could be permitted, and that outside of that zone, the council had agreed through policy that there should be no SEVs that were granted. And this venue does sit within that zone. It's on the boundary of that zone, and as some people may wish to point out, the actual pavement area in front of the venue is actually effectively outside of the zone. But I just wanted to clarify that for everyone's benefit. Finally, I'm almost finished. I just wanted to run through the annexes. We've obviously got Annex 1, which is the days and hours, which I'm sure everyone's aware of. And we've got the representations that have been made. We've got various submissions that the applicant has given to assist all parties in hearing this issue. There are some appendices to some of the objections that were made. As an example, I won't go into detail about them, but on page 65, reference was made and an appendix was attached regarding the Aarhus Convention. That was referred to in an objection. That's been included, obviously, for everyone's benefit and for everyone to have reference to that. And the final point I'd like to make is that all parties can obviously amplify and clarify the points that they've already made in writing. They shouldn't be going on beyond that, and they can obviously respond to the submissions, the written submissions that the applicant has made that have now actually gone into the public domain since the papers were published. And I think obviously the council has to make sure that there's a fair hearing, that the applicant isn't ambushed in any way where someone comes along with something that's new to all of that or isn't related to that new information. So hopefully that's clear for everyone. I'm happy to answer any questions.
Thank you. Are there any member questions? Councillor Boyce.
Thank you, Chair. My first question is, can you confirm, just for the sake of completeness really, can you confirm that this application doesn't trigger any grounds for refusal under the 5 mandatory grounds?
On page 8 of the report, it talks about mandatory grounds for refusal. Licence cannot be granted to someone under 18. Well, obviously, Mr Burrows is over 18. The person is not disqualified, that's not relevant. The person who is not resident in the estate, that's not relevant as far as I'm aware. To a body corporate which is not incorporated in the EA estate, that's not relevant as far as I'm aware. And 4.4e, to a person who's within a period of 12 months immediately preceding been refused. Again, I'm not aware that that is the case. Discretionary grounds for refusal, the applicant is considered unsuitable to hold a licence having been convicted or of an offence or any other reason. I'm not aware that any offence is engaged in that respect. If the business were to be granted, renewed or transferred, the business to which it relates would, again, a similar point under 4.5b. I'm not aware that that's relevant. 4.5c, the number of SEVs in the relevant locality. Again, that point is not relevant because there's not a number permitted in the designated permitted area. Obviously, 4.5d, there are issues that are engaged potentially there. So I think that the main focus on proceedings would be 4.5d.
Thank you. And my second question, which I think you probably answered, is have you ever had any complaints from customers to police or the public regarding premises run by this applicant?
I'm not aware of any such complaints. I can't speak, obviously, on behalf of other agencies, but I'm not aware of any complaints that have been made to us directly about this venue or other venues in, I would suggest, at least the last 3 years, probably. As I said, I can't speak for the police.
Any further questions? So I'm just going to... Sorry. Councillor Wheeler.
Sorry, just a very quick one. It just occurred to me. We're all aware that if we were to refuse this application, either entirely or in part, the applicant could open on a single night in a venue somewhere without our permission anyway. I can't remember for sure. So if we refused it on a specific night, could they operate a licence without our permission in that same venue? Yes, they could in another venue. Can they do it in this venue?
Thank you for that really nice technical question out of left field. I'm thinking that I'll look into it. I don't think I'm necessarily going to have a definitive answer. My gut feeling is that if you're providing that entertainment through the exemption, that would be classed as separately as where you're doing it under a licensed basis. So my gut kind of tells me that if you're doing it in a venue under a license for 2 nights in a given month, arguably you probably could still benefit from the exemption on a different night. I'll look into that, but that's what my gut's telling me.
I think from a legal perspective, regardless of what you do tonight, they can automatically rely on the exemption. So the exemption is almost an overriding principle. So that would be, so even if you said, for example, I'll just pick a random date, you can't have this activity on the 25th of December and you refuse it, the applicant can then still almost rely on his permitted exemption to run on the 25th of December.
Okay, so a couple from me. Just to clarify, when we're looking at the designated area, what we're actually looking at is the red line inside the premises where the licensable activity takes place. Is that correct? So our focus is on the area where the activity takes place in terms of our policy and the...
Yeah, the premises itself is in the area. However, I did think it was worth flagging up that it is obviously very, very close to the boundary, and in fact it's on the boundary. I don't know what considerations were made by the council when it set that boundary, but it seemed necessary to highlight that.
I think from recollection, it was to be mostly coterminous with the central core area but I may be wrong on that, but that was my recollection. The two other questions, which may be more legal rather than licensing, are, can you tell us whether the Aarhus Convention has relevance to this? Because my looking at it, it seemed to apply to very large planning applications for things like nuclear power stations and landfill sites and what have you, and I'm not sure that it's entirely material to our considerations.
I have a view on it, but Sarah might.
So in terms of the convention, it sets some very specific principles in relation to large-scale planning developments and some more general overarching principles. So the overarching principles is obviously in terms of decision-making, you should be open and transparent, you should take into account matters that are relevant rather than irrelevant. But in terms of very specific elements on this application, you must look towards the Local Government Miscellaneous Provisions Act, which sets out the rules and the guidance on how you determine these applications, and that's your primary piece of legislation to look at.
Thank you. And the second one is, in terms of the public sector equality duty, I think there are some principles which I've noted down as the Brown principles of explaining what's meant by due regard. And that might well be one more for legal rather than Jason, but my understanding is that's been looked at by case law, and it doesn't mean we have to show that we've considered it, but it doesn't, it's not an absolute legal we are required to show we've considered it.
I think the easiest thing is to say you must pay due regard to the public sector equalities duty. It doesn't fetter your discretion in terms of decision making, that you have to make X decision rather than Y decision, but what you have to look at is the overarching principles within that, and in particular in relation to those persons who have protected characteristics such as sex, age, race, religious beliefs and things like that. But I can't add anything more unless you want me to speak for about 3 hours on public sector equalities duty.
Right, thank you. Just checking there's no more questions from members. Right, are there any questions from the applicant or their representative, or is that all clear? Can you use the mic?
Thank you.
While you're there, can you check that Mr. Barrows...
Sorry, yeah, it's just to clarify, the renewal date, I think, is actually the 6th of December, is it not, on the SCV licence? It's just a point of clarification, that's all.
I think that it's not quite as similar as, say, with a premises licence or a taxi driver's licence. The end date and the start date's a little bit arbitrary because normally it's only referring to something like March. So I think it's not going to be an issue in terms of whatever the decision is of the committee.
Thank you. And are there any questions from the objectors based on what you've heard from the report? Yep.
I think it's working. Yeah, I just had a question about the contents of the report and how what we've heard around sort of sexual entertainment venue licensing and frequency exemption, how that sits with some of the advice given in the adult entertainment guidance note that's on the Cheltenham Borough Council website. So my reading of the adult entertainment guidance note suggests that premises licences might contain a prohibition on adult entertainment. So I just I was interested to know in what circumstances such a prohibition might be imposed as part of a premises licence, and then how that does interact with sexual entertainment venue licensing and the frequency exemption.
I'm not aware where that is. If you can let me know where it is, then during the course of things, I'll try and look it up. But that's not something I'm aware of. What did you call it?
The adult entertainment guidance. Jason, can you
I'll try and come back to you when I can.
I think I've managed to find it, so bear with me a second.
Yeah, I'll just use the search.
If you search, that should come up as the...
Yeah, it's going to take me 5 minutes to read it.
Okay. Bear with me on that. Right. Are there any further questions? I'm not seeing any. We'll now move to the objectors getting their opportunity to speak. Before that happens, I need to just make a few things clear. So firstly, your verbal representations are to expand on and clarify your written representations. You can't use this opportunity to seek to introduce new evidence, as the applicant will not have had an opportunity to review it, which would violate their right to a fair hearing. Secondly, while people may disagree on matters, I would ask everyone to do so with courtesy and respect, specifically using non-pejorative language such as premises to describe the location, SEV or licensable activity to describe what's being licensed, applicant, performer, dancer or employee to describe the people who work there in the various capacities. Finally, I want to address a number of matters that have been raised in the written objections. It's an application for a sexual entertainment venue licence, and there is no evidence whatsoever that prostitution occurs on the site, nor that any performer is involved in such activities at the premises. There is a licensing condition to prevent the exchange of contact details between performers and customers. There is also no evidence that anyone is coerced, trafficked, or the victim of modern slavery, and the applicant has robust checks in place to prevent this, and there is a licensing condition requiring the provision of materials to make performers aware of these issues. If you raise these in your clarification, I will interrupt you, not to prevent your freedom of speech, but because this is not an environment where you have privileged speech is possible, and there'd be a significant likelihood you'd be defaming either the applicant or the performers. Since the objections are anonymised, you'll be asked to address the committee using the representation number in our document bundle. Hopefully you know which number you are. Has that been... Can I just check that?
No, it's in your script, and that's the objector number.
Yeah.
But they maybe will only know that from looking at the one.
Right, okay. So we may need to just work out who we've got, but so we'd ask you to limit the address to 10 minutes, and then there'll be an opportunity for questions. So the first person I've got is objector number 28. Now, do we know? Do I need to? Okay. Right, okay. Let me find it.
Can you access it?
Just trying to find out. I can maybe... So 28, 28 is a reasonably short one that says, I'm writing to object to the application for the extension. Yep. Okay, we may have a slight disconnect between trying to anonymise the objections and actually working out which ones they are. So if we just start and go round from this end, and then we can hopefully work out which piece of text relates to which person.
I think I know which is our objection. So I'm a representative of Gloucestershire Women's Liberation Collective, Gloss Women. So I think we're named in the list of objectors. I think we're number 18.
Yep, so please begin.
Thank you. Yeah, my intention is just to read a short statement on behalf of our members. Gloucestershire Women's Liberation Collective would like to thank the Licensing Committee for this opportunity to contribute to this evening's meeting. We object to the application made by Red Apple Associates Limited to renew and vary their existing sexual entertainment venue licence to allow for lap dancing at Jessup House to coincide with race meets throughout the year. We note again that our letter was one of a number of objections expressing concern about the negative impact that sexual entertainment venues have on the lives of women and girls in Cheltenham. Gloss Women, along with a number of other objectors, attended and contributed to the Licensing Committee meeting on the 4th of October 2023, where a variation of an existing licence under the prom was granted to allow for lap dancing to take place during the November race meet. We were pleased that objections made on the basis of sex equality concerns were not dismissed by the Licensing Committee as moral objections, as has been the case previously. We hope this change in approach will allow for more detailed consideration of the impact of the sex trade on women and girls and how this contributes to sexist and misogynistic attitudes that drive male violence against women and girls in society during tonight's meeting. A council committed to helping bring about an end to male violence against women and girls will no doubt give detailed consideration to the root causes of such violence and the part that the sex trade plays in creating a culture where the abuse of women and girls is endemic. Thank you.
Thank you. Are there any questions for our speaker from members? I'm not seeing any. So thank you very much. No, there's no obvious questions. I think the new constitution means I should ask the applicant if there are any questions through the chair that you want clarified. Okay, thank you. So if I can now move to our next speaker, please.
Okay, thank you. My objection is number 20. Section 12.4 of the Council's SEV policy statement contains 4 criteria under which properties within the designated area that are in sensitive locations can be declined. Jessup House meets all of these criteria, and a case for the refusal of this application exists. Furthermore, the policy contains 40 standard conditions which the committee has the power to enforce or deviate from. Pardon me. The plans and supplementary information submitted for the venue do not provide measurements for the booths within which performances will take place. This is required by Section 2.5 of the policy. Condition 18 states that there can be no physical contact between the performer and customer, and point 6 of the Adult Entertainment Guidance Note requires a safe distance of 1 metre. Unless there is observation of all booths at all times, it is not possible to guarantee that there will be no physical contact between performer and customer or the safe distance maintained. The fact that the application describes security personnel as booth walkers suggests that this will not be the case. Based on the points above, the committee cannot be assured that these conditions will be met. This presents safeguarding risks for both performers and customers. The supplementary information includes reference to a refuge area for performers manned by an SIA member of the door staff. The dictionary definition of refuge is a place that shelters or protects from danger, distress or calamity. The inclusion of this area in the language used to describe it identifies the safeguarding risk to performers during the operation of this venue. We need to ask ourselves how many workplaces of areas that are described as a refuge with security provided. I believe this is concerning. The above is the basis of my objection to this application and variations. If the committee grants this licence, regardless of the sensitive nature of the location, I would ask that it uses the powers it does have to enforce and not deviate from the standard conditions contained within the Council's sexual entertainment policy statement, and that performances in booths are not permitted given the safeguarding risks that exist.
Thank you. Are there any questions for the objector from the committee? I'm not seeing any hands. Through the chair, are there any questions from the applicant? No? Okay. Moving round. If you know which objection number you've got, could you please tell us?
I can. Our objection is number 24. Okay. All right. So just a short statement in terms of who I represent. Sexual violence is a serious and widespread issue, and then bearing in mind that the government definition is the purpose of sexual entertainment venues is to sexually stimulate those observing. Those two statements concern me because of how one leads on to the other. I think that the application that's been submitted this time round is for being a numerous events throughout the year is a significant variation. I'm very aware that it will be, I note, on the boundary, but in a much more residential area than previously. In the surveys held by the Cheltenham Borough Council in 2021, where it was reported that, 72% of respondents told us that they don't feel safe at night in the Cheltenham area. That rises, not much, admittedly, during race week, but my concern is that it still continues to rise during any other race events. And overall, nationally, in terms of government figures, 97% of women nationally between the ages of 18 to 24 report on harassment in the streets. I note that Cheltenham Borough Council also repeating or renewing their question survey that's out until the end of January of next year in relation to the safety that women feel on the streets. So I think this is all linked to it. Previous research, not from Cheltenham Borough Council, but nationally, said there was a 50% increase in reported rapes in the vicinity of sexual entertainment venues, and also an increase in measurable effects, i.e. women feeling unsafe, and increased rates of harassment. I suppose in that regard, I see that the Council has a duty to eliminate discrimination, harassment and victimisation under the Equality Act, and Grassac, on behalf of its clients, would hope and expect that the Council do its power to ensure the safety of women and girls in the town, around the streets and in the areas, and I feel that this licence application goes against that.
Oh, microphone. Are there any questions for the objector from members? Okay. Thought I had a question. Bear with me. So, Grassac, from memory, Grassac were involved in the consultation on the last SEV policy. But can I confirm you were involved in it, and then when it went out to consultation, that there was no further response to the policy from Grassac?
And when would that have been that the consultation was? I only say that because I've been in post for the last 11 months, so if it was before that, I can't comment, I'm afraid.
That's fine. In which case, it was probably before that.
I feel sure that it was from my recollection of reading reports. We'll happily comment on future policies.
Thank you. And finally, from the objectors that are listed, sir, on the end.
My name's Elwyn Barry. I'm happy for that to be known. I'm senior pastor of Cambrai Baptist Church, and the church is just opposite the venue concerned. I represent the trustees of the church who've written in, and I think it was number 25, am I correct? If that's right? Yeah, okay. So I represent over 300 adults and 100 children, young people who regularly attend and worship Cambrai Baptist Church, as well as hundreds of others who meet in and around the church building every week. I realise, ladies and gentlemen of the committee, that you have a very difficult task here with many concerns to balance, and so I do want to thank you for the opportunity to speak to you. You will have read our written submission. You'll see within that written submission there are strong reasons why you can, without challenge, use your discretionary powers given in section 4.5 in D 1 to 2 and in 4.10 from A to D to refuse this and indeed any future application. In hearing last November, the Chair warned the committee of potential legal challenges if the application is refused, but a decision to refuse permission, although it may seem bold, is one that supports the facts of the case, and you do have ability to do so. Given the case has already been made in our submission, I want to take the opportunity to do what I'm allowed to do here, which is to amplify one aspect. I could amplify many, but I want to amplify one aspect only, which is the sensitivity of the proximity to a place of worship, and that there is nothing that can change that. I do not think I can overemphasize the degree of offence the licensing of this establishment in the current location has generated. It's generated offence in those who are not associated with the church, who have expressed to us, come to us to express, how insensitive it is that such a business be given permission to operate in that location. It's generated offence in those who bring children and young people to events and the regular provision of the church, some of whom have expressed grave concern about bringing children into the area whilst it is operating, and some who have actually refused to bring children to the activities that we run, even to drop them off in the Rodney Road entrance that we have, because of the very fact that the business is in the area. It's generated offence among those within other churches in the town, who see this as another attack on the protections offered to churches and to religious organisations in this country. A liberal society provides not only the opportunity, but also the protection to those with differing views and opinions. And churches are given protection under law, and yet it looks to those who are looking on that the council are unwilling to act lawfully in providing that protection, particularly as it's not the first time that a sexual entertainment venue has been permitted to be sited immediately opposite a place of worship. It's generated offence within our own church family. It's as insensitive, in fact, much more so, than placing a pub immediately opposite an Alcoholics Anonymous venue, or a betting shop at the entrance to a gambler's rehab centre. Where marriage is upheld, immediately opposite us, licentiousness is being promoted. Where family life is honoured, immediately opposite us, infidelity is offered. Where women's value is held in the highest regard, immediately opposite us, the objectification of women is normalised. Where new life is offered, immediately opposite us, broken lives are served. It's discriminatory, of course, to Christians for such a venue to be placed in this location. Christians in Cheltenham are not being offered equal concern that's been given elsewhere in the country to mosques and to synagogues. Members of the licensing committee, you have no idea how deeply hurtful the presence of this business is. And it's only one of the many areas I could have spoken on. You do have strong legal grounds for discretionary decision to turn down this application. And I urge you this evening to be bold, and it will take courage in your decision making, and not hesitate to use these grounds in this instance.
Thank you. Are there any questions from members? So I've just probably got one, which is, you obviously heard the discussion about the exemption, where the activity can occur anyway at the premises without a licence and without the protections of all the licensing conditions. So of the two things that the two possible outcomes of it being licensed and there being conditions, or it happening anyway but being unlicensed, which is effectively the choice we have to make, not necessarily for all the dates, but for some of the dates. Of those two choices, which is probably not a choice you wish to choose between, which of those would be preferable?
There would be protection under law for churches regardless of that. We would have to obviously go to law for that, but there's protection under law.
Thank you. If I can now move on to our councillors who you really should have registered. You're in a position where you should have known this, but our discretion will, or by discretion, I'll let you both address. So if I can ask Councillor Barnes first, or Councillor Dobie? Councillor Dobie.
First of all, Chair, can I thank you for your discretion in allowing me to speak. My name is Ian Dobie. I'm one of the two councillors for College Ward, where this proposed SEV is possibly going to be located. I won't repeat my detailed written submission and objection, which has been indeed endorsed by my fellow councillor here. I wanted briefly to highlight a couple of points about the other submissions in objection, actually, and next my vastly experienced fellow councillor, College Ward, Councillor Barnes, will speak. So, to my 2 points. Firstly, the number of objections submitted, many from our local constituents, outnumber those in support. The objections are clearly heartfelt and individual. They're not pro forma. And secondly, I want to turn to the objection from Alex Chalk, MP for Cheltenham. Now, Mr. Chalk is, of course, no friend or ally of mine. Indeed, every week I campaign for him to lose his job. Nevertheless, professionally, he is clearly an eminent lawyer. Indeed, he is the most senior lawyer in the government. And, of course, it is the government which...
Councillor Dobie, I think we're going off topic here, in the sense of you need to speak to your objection, not to someone who's not here.
Objection is endorsed by him in that what he is saying, and in one sentence, what he is saying is that you, as the committee, have the power, the legal discretion to turn this down. And I urge you to use that discretion on behalf of my constituents and the people of Cheltenham. Thank you.
Thank you. Are there any questions? Councillor Wheeler.
Is Councillor Dobie aware that Alex Chalk MP has the power to ban SEVs completely, make a law against them? It is his job within government. So rather than write to us to ask us to use power...
I think we're verging into politics here. We need to be rather careful. Mr. Chalk, for whatever reason, isn't here this evening. He didn't register to speak. He's not here. So I think we need to be careful on this. Are there any other questions? So I've got a couple for you. Firstly, the same question, pretty much the same question. You've heard the explanation of the exemption which exists in law, where the activity can occur infrequently, so no more than 24 hours, at least a month apart, no more than 11 times a year, with no licensing conditions, or it can occur and it can occur at this venue, or it can occur with licensing conditions that are there to protect performers, public, employees, customers, etc. Which of those two do you think provides the greater safety for the public?
I didn't realise I was going to be put on the spot on that thing. I mean, I know the point that you're making, of course I do. I accept that that's the legal position. And I also know the fact that our MP could stop this through the Parliament if he wanted to. And I think it's outrageous that he didn't.
Okay, thank you. And the second question, so in the objection, let me just find it. You've made some allegations, as it were, where it is claimed the performers are under coercion. It is claimed, and where is that? So
I didn't say that they were under coercion. At no time did I say that they were under coercion.
I'll read it to you. It says, there is scepticism that regulation by the council provides sufficient protection. It is claimed the dancers are likely to be under coercion by employers to provide formulaic statements of assurance which may not be true.
I didn't say that. I didn't say myself that they were being coerced. I said that's a repetition of things that have been said to me. And if you reject that, then you're rejecting, potentially hearsay, but it was repeated to me. And if that's to be struck out, then please strike it out.
Okay. Are there any further questions? Any from the applicant through the chair? No? Okay. Councillor Barnes.
Thank you, Chair. Again, I thank you for your indulgence. I was under the impression that I had asked to speak, but I clearly have got the protocol out of context. So I have a reputation for asking the committee to not approve these sexual venues, in particular with the Gentlemen's Club in the Bath Road. And I know this isn't part of the process tonight, but I argued on many occasions that it was in the wrong place, and that indeed it fell outside of the permitted perimeter that the council had agreed. I was told that didn't really matter because it was only a few yards outside of the permitted area. Now we're arguing that this one is only a few yards inside the permitted area, but we should agree that it goes ahead. Now, I think that's a bit of duplicity on the council's part, and I would object to that on those grounds. I think clearly the pastor has already said most of the reasons why we should use our discretion to stop this SEV going. And I would just like to add a couple of things. One is that not only is it close to a church and to many residential, an area of high residential impact, but it also has in Cambridge Place is a mental health facility which counsels victims of sexual assault and people who have left the sex trade. I think it's totally inappropriate to have a sex venue that is in that vicinity, considering that circumstance. And also, I'd like to just read to you one line from the venue's website. And it says, "Are you ready for eroticats? The strippers in Cheltenham are ready to show you everything they've got." Now, we're a purple flag town promoting the area as being a safe and lovely place to be in. And that kind of advert is going out on their website. How does that promote our purple flag scheme. I think the reputation that it's destroying for the town is very pertinent. I think there are a lot of points that have been made in this, in the objections, and I would agree with most of them. But I do think that we, on a wider note, I think this council needs to look at its policy on sexual venues, because I think it is out of date. I think things have moved on, and I think we clearly need to look at why we promote these events in Cheltenham. Thank you.
Thank you. Any questions from members? So you, just one for you. You were a councillor when the policy last went out to consultation. Did you respond to the consultation at the time?
I can't remember in detail. Perhaps that sounds like Rishi Sunak's defence, but I can't recall actually having said anything. But I'm sure I would have thought that I did, because I have always disagreed with the policy that we've had. And I know the question you asked our colleagues before about whether I would prefer something to be licensed where it was looked, checked over by the licensing officers and all the rest of it, or whether I'd prefer people to use the exemptions. I think that's a false premise, really, because you can have single events regardless of whether or not you have a licensed premises. And, they are going to happen anyway, because we have no way of stopping them, unfortunately. But it's to ask whether or not you prefer licensed girls showing everything, or whether you prefer an establishment to open up for one night only and doing whatever they want to do, I think is not pertinent to the general question of the policy of SEVs, in my view.
Thank you. Okay, yeah, do you want to come back on the question then?
Yeah, if I could just come back on the point that was raised earlier about the guidance that we've got. Obviously, this is relating to the guidance that we've got on our website, which is entitled Adult Entertainment Guidance Note. Although it's well-intentioned, I don't think it's particularly helpful. Okay, it doesn't make certain things out very clearly, and obviously you've taken something away from it that's not actually the case, or potentially not the case. Just to give a couple of practical examples, if I'm setting up a new business and I make a premises licence application to sell alcohol, if when I'm making that application, I should tick the box and I should put on the form, I am going to provide relevant entertainment, and the police or anyone else could make comments in the context of that commitment on my application. And the application would be considered in the normal way. I think it's very unlikely, and I think our solicitor would have a strong opinion on this. The primary legislation allows the venue to use the exemption. I don't think it's open to the council to use a condition to override primary legislation. The police might want to put some conditions on that licence, and that might be justifiable, but actually I don't think we could bar that happening through that means. Furthermore, if when I make that application I'm not thinking of doing relevant entertainment, I make my application and 6 months later I decide I'm going to start doing relevant entertainment, I don't have to tell the police, I don't have to tell anyone else if I'm going to make use of that exemption. And the only way that the police could then actually do something about that would be if they reviewed my licence if there was a problem. Also, the guidance isn't particularly helpful because it suggests that a temporary event notice would be required in all instances where relevant entertainment would be provided through the exemption. That's only the case if a venue is going to sell alcohol. Okay, so if a venue was to operate bring your own only, or was to not sell alcohol, it doesn't need the entertainment, the music and dancing element, the regulated entertainment. It doesn't need that licensed because the legislation specifically excludes that from being considered as regulated entertainment. And so this notion that to take use of the exemption, you'd have to have a temporary event notice or you'd have to have a premises licence isn't necessarily exactly the case. Hopefully that clarifies things a little bit. It just what that actually kind of expands on is that actually it's more easy for a venue to make use of that exemption, and for the police or anyone else to not be aware of that. Hopefully that's helpful.
Is there a question? Can you use the microphone?
Sorry, I didn't just want to interrupt. It's a kind of question and a comment, if I may be permitted, in relation to the adult entertainment guidance note and the comments about equity of this process. I don't have the email with me, but now in fairly short timescale, this is the second piece of information on the council's website in relation to licensing that residents and objectors are seeking access to. We're lay folk, so I do believe we are entitled that information we gather from the council website is accurate, factual and correct. And I think that really kind of plays into the equity that the chair of the committee shared earlier, so I really would just like to mention that, and I think there's a point of concern there in relation to how we access democracy and how we are given equity in relation to this process.
I mean, do you want to come back?
I think all I would say, I think that's related to something that we actually had a conversation about, and I thought in my response I made things quite clear, and if I didn't, notwithstanding that document could be considered as not being fully correct, and that's obviously something we need to go away and look at that and make sure that it is accurate. But it would have been helpful to have known that before the hearing, because that obviously something we could have addressed. But it was pretty much, I thought we'd covered that in the conversation that we'd had on email, which doesn't help everyone else, I'm aware of that.
Well, what I would say to that is the other element that we covered in the email exchange was actually a different source. So these are two separate sources that two of us have come across differently. So I'm afraid I don't take your point in totality. So, and I've relied on this as well. And I think it is about equity, about when we make representations based on information on a council website, that, that they are fair. It's important that this is a fair and equitable process for all of us, whatever our position is.
I think the council would have made sure the document was up to date at the time it was published, and it probably has a date on it. But case law moves on. We've had to update this following the case law of BCP, the case law with Bournemouth, Christchurch and Poole Council. We've had to update some of the things that we're doing. The law is not static. If there's case law, we have to update it. So policies will be accurate as and when they were written. Things can change. Right, moving on. We now need to move to hear from our supporter. And I just need to check that everything's ready for a person to speak and not be seen. So if you're watching on webcast, then there won't be any video of this part of the meeting. So if we can hear from our supporter, please. I'm not sure where they are. There we go.
I've worked for Eroticats from the beginning, so that's around 12 years now. As a performer for around 5 years before I took my current role as senior house member. My role within the operation includes, but is not limited to, ensuring all performers feel safe and comfortable from start to finish, making sure every performer knows the procedure, layout, rules of the event, being available for any advice, guidance or issues that performers may have, and finding solutions to the aforementioned. This is something I take incredibly seriously and I'm very passionate about. I work alongside an excellent security team and Mr Burrows and other members of staff. I would like to emphasise the importance of licensed venues. I've worked for over a decade in about 30 clubs in the UK and others abroad. Rock Cats is without a doubt the most organised, safe and well-run operation I've ever encountered. If I did not wholeheartedly myself believe this business to be safe and fair, I would not be sat here today. I personally have encountered some very questionable practices and management in my career at other venues in the UK. The only way to ensure all performers and customers have a positive experience is to licence and regulate these kind of events and venues. I'm always saddened by the negative reception these licences often receive in the media. As dancers, we are tired of being spoken for rather than to, and portrayed as having no other option than partaking in dancing and sexual entertainment. This is simply untrue. Many of us have other jobs, businesses, commitments. And I'll mention that we don't appreciate comments implying we're selling sex or our bodies. I do still have all my limbs. I support the view that women should be safe, respected and supported in and out of work, but I do not support their choice to earn money how they choose being taken away because of incorrect assumptions and the stigma of the industry. To grant this licence means we have a regular, safe, structured premises to work that is regulated by laws and conditions that I welcome. Thank you.
Thank you very much. Are there any questions from the committee? So just a couple from me. First one, is there anything that you think that we as a council could or should do by virtue of any licensing conditions that would make you feel safer?
Not off the top of my head. I think there's a lot of conditions that we have already that I completely understand and support all of them, 100%. And although you sort of said this to in your representation, can you confirm that you feel safer working at a licensed venue, whether you feel safer working at a licensed venue that stays in the same place with a licence, or one that moves around using the exemption? 100%. We, in the early days, I think we did use the exemption and moved around, and that was an absolute nightmare for performers, to be honest with you. And I have worked for unlicensed events in other places before, and quite frankly, if you think licensed ones are a problem, then you want to see the ones that aren't.
Okay, thank you. No other questions? Right, at this point, I now need to ask Imogen Moss to address the committee on behalf of the applicant. I think we were at about 25 minutes of objections, so if that works for you, that's okay. Thank you.
Yeah, so I'll try and keep this as to the salient points only. You'll have received our disclosure bundle. We've provided quite a lot of information there, above and beyond actually what is actually required under the Act in respect of a renewal or a variation application. Being open and transparent as to how the operation is at the venue, which is just a benefit to everybody in part of the consultation process. As you've heard, it's a renewal application including retaining the varied condition 6 for the SEV licence that was granted 22-23 and that traded in March of this year without any concerns raised by the police or the council in respect of the SEV operation. It's important to note that these don't operate in a vacuum. It's not that these licences are granted and then nothing happens with them, they just operate. There's constant monitoring of all kinds of different venues, licensed venues. And in Race Week, there are briefings, regular briefings held with the police, and there's unfettered access to council members to go and visit and inspect these venues. And when we operated this venue back in March, there were no issues raised that we're aware of. The application is also to add in some additional race events in addition to the sort of the March and November dates that are the general ones that are operated to. It allows some flexibility, it sets out the projection, it sets out for everybody a clear viewpoint as to what those operations are going to be and when it's going to be operated. And again, I just want to kind of, in the interest of time, look at the key themes of the objections and discuss the merits of the application as well. So looking at locality. So the Council SCV policy specifies a designated permitted area, and the policy states that the designated permitted area offers a more varied situation, as has a wide variety of businesses on offer, particularly in the nighttime economy, as is the case around Cambray Place. It's not a venue that operates in isolation. There's lots of other venues in and around that area, late night venues, cafes, all those kind of things. It's a very, very multi-use area within the designated permitted area. And the policy says it may therefore be appropriate to consider applications for an SEV in that area. On the initial grant, the licensing committee determined that the premises was a suitable location, and the locality hasn't changed since the initial grant. Of course, the decision regarding what constitutes relevant locality is a matter for committee to determine today, but I would stress that the area in the vicinity of the venue is a recognised commercial location and has been for many years. The frequency of the use of the venue as an SCV, as well as the hours applied for, together with things like the frontage of the premises being discrete, is such that we suggest that the impact on the locality is minimal. The application is for a set number of days during the year, and it's very clear as to the limited frequency. We're not asking for 365 days of the year, we're asking for a very limited number of days for the operation. Looking at Cambray Place, again, I think we've looked at the actual website that shows what's on different days at the church. You can see that on a lot of the dates through March, it's the Rodney Hall at the back. Cambray Place isn't visible, Jessup House isn't visible from that side of the road. You wouldn't know that it's an SCV. Our customers aren't any different to late night venues, late night bars, just ordinary people going to an ordinary, completely legitimate venue. So, for example, March, Rodney Road, some of them move between homes or at a sports centre. Some of the events are at the badminton, for badminton at the Rodney Hall, again at the back. In April, we've got an event on at Bourneside School, and I'm just talking about times that may overlap with the hours that we've applied for. Another date in April, I can't see any event that coincides. So you can see that we are not, by virtue of being in existence there, preventing people from using that facility to practice their faith. We are not encroaching on anybody's ability to practice their faith. Bearing in mind also as well, when this venue operates, there are distinct things that are worth bearing in mind, which is the signage on the outside of the venue has to be very specific and agreed, and we've provided some of that in our disclosures. The windows are blacked out, you can't see in, and there's no SCV activity on the ground floor. So it's all very discreet, but for the fact that we're at this hearing, you wouldn't really necessarily know if you were a stranger to the town that that's there. It's just a late night venue as much as anybody else. Again, we're operating on limited occasions. Some of the objections refer to Sunday worship and things like that. We're not operating on Sundays when that would be happening. There's no overlap there. People frequenting the SCV venue are normal members of the public, all types of ages, backgrounds, genders, females, couples. Again, nothing that distinguishes customers of an SCV from a customer of a nightlife venue. The only distinction I would make is that the behaviour requirements of an SCV venue are much more stringent than that of a vertical drinking establishment, a nightclub, a bar. The expectation as to how you behave and how you conduct yourself is far greater. I just wanted to touch on some of the other venues that have been mentioned in the objections as well. I'm not going to go through all of them for the sake of time, but we mentioned local toy shops, they shut at 6. There was a mention of the Salvation Army. That's a 4-minute walk away, accessible from a variety of different locations. I couldn't see on their website an overlap in respect of operating times. Oxfam shuts at 5, again accessible from a variety of different locations. And cafes, don't forget our own venue operates as a cafe during the day. This isn't the core of our business. We have the cafe operation and then the evening operation as well during the rest of the year. So the impact on the locality is very minimal due to the small frequencies proposed and the hours applied for, and also the stringent conditions that we have to comply with in respect of the exterior of the venue as well. Some of the representations also talk about women's safety, and there's an assertion that the presence of the SEV venue means that there's an increase in crime and women's safety is at threat. There's no direct evidence that that's correct. If there was any evidence that the operation of the SEV or any SEV in Cheltenham is directly linked to any increase in violent or sexual crime, the police would have objected to the application on the grounds of crime and disorder in respect of women's safety and provided relevant data and statistics. They have not. Statistics quoted in some of the representations from the 2021 survey that 72% of the respondents state they do not feel safe at night, rising to 75% during race week. Disappointing statistic for sure, but it's not one that can be laid solely at the door of the SEV venue at Cambray Place, especially when the venue only operated once, 6 days last year, and is applying for renewal with additional dates, but still very limited. The rise of 3% is also to be measured against the thousands of people that come into Cheltenham during race week. The report on safety of women at night from 2021 looks at the statistics and states that respondents told Cheltenham Borough Council that all parts of the nighttime economy need to take this issue of sexual violence seriously. That's not limited to SEV venues, that's the entirety of the nighttime economy. There are many complex reasons for people feeling unsafe: time of year, availability of taxis, lighting, personal experience. I could go on. But I do want to draw attention to the DCMS examination of witnesses on October the 18th, 2008, where a Chief Inspector told the Commons that clubs such as SEVs were usually well run and had high staff-to-customer ratios. He stated it's true to say there's no evidence that they cause crime and disorder, or very rarely, because they tend to be fairly well run. And people frequenting those kinds of venues tend to be a bit older and they don't drink so excessively. They're not a vertical drinking establishment, they're going there for entertainment. Therefore, again, the behaviour levels are somewhat different to your traditional nightclub. Looking at the statistics mentioned, it's also worth pointing out that the SEV at Jessup House, it doesn't have every single person visiting a race event in Cheltenham Centre through its doors during race week or any other race event. So inferences in the objections that behaviours are exclusively down to people having visited the SEV venues is simply not correct and doesn't have any evidential basis. The Council's own SEV policy review meeting in 2019 recognised this, where, and I quote, members noted there was inevitably a spike in crime rates during race week due to the increased number of people coming into town who are intoxicated, and there was no evidence to suggest that SEVs contributed to the increase in crime. In any event, being aware of the overarching figures and also being an active member in the Cheltenham town, having the business, you know, the late night venue and the coffee shop during the day, the operator has worked hard to look what it can do to assist in the promotion of women's safety in town. And that includes the 20 to 25 staff members in the town with the pink tabards during race events, and that helps in the promotion of women's safety, and all of those staff members have undergone bystander training. So moving on to performer safety as well, because that has been raised in a number of the objections also, and you can hear, if you've heard from one of the people that put in a representation of support, performer safety is of utmost importance to the operator. The fact it's taken so seriously is evidenced by the fact that they have returning performers year on year. You know, the operator's only having the SEV venue on a limited number of occasions throughout any year, so the first one being March of this year. The fact that they already want to come back and work at this venue is an indication of how safe they feel. Mr Burrows has a wealth of experience in operating SEV venues in Cheltenham, and there's a wealth of extensive legislation which covers and offers further safeguarding. It's also worth noting in the SCV policy review on the 17th of July 2019, a member stated that they were extremely impressed with the setup at the Two Pigs when they had visited during race week. So that's another venue that was previously operated, particularly with regard to the safety of performers and the checks carried out on performers. And we've also heard from a performer and a house mother who can testify to the experience of performers at the venue. Having a licensed regulated venue is a far safer way of ensuring performer welfare than having to rely on exemption rules. The Scrutiny Task Group report on the sex trade in Cheltenham 2013 stated police advised they'd seen no evidence of a link between the licensed and unlicensed sex trade, and I think that's also important to bear in mind. We have the minibus, which is used to assist with performer safety as well, in respect of transportation to and from the venue. That provides additional security and reassurance in light of issues with obtaining taxis or illegal taxis. And again, I come back to the point that council officers and police have unfettered access to the SCV venue when in operation, and inspections do take place nightly, every night that they trade, on more than one occasion. If there was any hint of concerns regarding performer welfare, performer safety, then we would have seen the police objection and we would have seen the council raise issues with the applicant and the application process. You'll have seen from the disclosures the general steps that are taken in respect of the operation, and of course these will have been also seen in reference to the council inspections. There is a set refuge area. Refuge is also known as a place of rest for performers to take breaks, and there's literature provided there in respect of all the required documentation which is required as a standard condition, so modern slavery, domestic abuse, coercive control, etc., and these are always available. There's a significant number of door staff on site when operating as an SEV, and the operator has stated before on the grant of the original SCV licence that they actually have more than the required ratio, including the booth walkers who are SIO registers who constantly monitor the booth areas. I just wanted to address as well, before I move on to the merits of the application, the public sector equality duty. So the Journal of Licensing, July 2022, looks in depth at specifically at SEVs and the public sector equality duty in an article written by Jeremy Phillips, KC, and Michael Feeney. The key points to note are many organisations, such as the International Union of Sex Workers, argue that sex workers have the right to work in gainful employment in a safe and properly regulated environment. Licensing, in particular the ability to impose licensing conditions, gives local authorities considerable power to control and regulate SEVs. A study commissioned by the Home Office noted that some workers identified that the revocation of many SEV licences without the attendant scrutiny of working conditions as problematic. Another quote is, a complete ban on SEVs and subsequent deregulation would create tension between supporters of such measures and those who see sex work as a legitimate and consensual form of entertainment provided that is made safe for all those concerned, and the key point there is properly regulated. Lastly, it's crucial to remember that the public sector equality duty doesn't require a specific outcome. The duty is to have due regard to the 3 equality objectives. So lastly, looking at the merits of the application. So the suitability of the applicant, wealth of experience, works with authorities, has a collaborative approach to working with the community. The SCV is in respect of a limited number of days and hours throughout the year. This is not a 365-day-a-year application for all hours of the day. Significant weight should be given to the fact that there's been no change to the locality, and no real evidence has been given that there's any direct adverse impact on premises in that locality. And I'll come back to my previous comments in respect of how the venue is operated, how it's dealt with, and looked how you see it externally. There's no evidence that the operation of the venue as an SCV premises contributes to crime statistics. It's simply not the case that the venue operating on a limited number of occasions each year as an SCV means that there's a significant rise in antisocial behaviour or a rise in sexual assault cases. If these were concerns, the police would have raised issues, and significant weight should be given to the fact that they have not. SCVs are a lawful activity. Not enabling venues to operate SCVs can further stigmatise workers and actually make it harder to maintain or enhance established workers' rights and can disproportionately negatively impact the livelihood of predominantly female performers. The venue operated in March of 2023 with no issues or concerns raised in the debrief, and I think that's really important. Staff have undergone training on vulnerability, anti-sexual harassment and bystander training organised by the council. The operator has also approached GRASAC to attain literature for performers for the welfare folder as well. The management, Eroticots management, have undergone the bystander training that formed part of the Police Crime Commissioner budget and was one of only, I think, 2 licensed venues that took part. They've had numerous meetings with GRASAC and the council. And this is a known operator who's operated SCV activities in the town for many years with no issues and has a proven history of partnership working. And I think the key point that I want to come down to is it's better to be licensed than to rely on the exemption. I provided a number of the conditions, or all of the conditions, standard and the varied condition that apply to the SCV licence, because I think it's really important for people to see how regulated these venues are. Also detailed at paragraph 6.8 of the Council's report regarding the adoption of the revised SCV policy from the 11th of February 2020 states, recognising that sexual entertainment is a lawful activity, officers are of the view that it is better for the Council to regulate SCV through licensing. Venues operating under statutory exemption are free from any licensing regulation and control. It's easier to monitor and control premises with an SCV licence rather than uses under the statutory exemption where it can move from one venue to another. An SCV licence, as you can see from the disclosures, has a significant number of robust conditions and is highly regulated. But I also just want to mention as well that the exemption, it's not a loophole. That word came up quite a lot in my objections. It's not a loophole or an omission in law. The Act specifically provides for the exemption for relevant entertainment on an occasional basis. This is a professional business with a proven history of running well-regulated venues that all responsible authorities are able to better monitor, regulate and have that unfettered access to if it's all at one venue. The positive representation supporting the application demonstrate that many of the concerns raised within the representations are without evidence to support them. And I would ask the committee to conclude that the locality, especially, is suitable for this premises and grant the renewed SCV licence, including the varied condition 6 and the varied dates and hours that we've applied for. And if you've got any questions, let me know.
Thank you very much. Are there any questions for the applicant? Councillor Boyes.
Thank you. I just have the one question. It's something that had been raised in the objection, so I just wanted to cover off on it. The premises are situated in a residential area. What steps are you taking or do you take to mitigate against any disruption or disturbances to local residents?
SCV licences, by their very nature, are less they have less impact because things like noise, for example, you're not like a nightclub venue where you're having louder regulated entertainment such as live music or recorded music. An SCV licence is going to have low-level music, and I'm sure Mr Burrows will jump in, but you have to be able to hear one another to operate it properly for the communication to be between staff and performers. So actually any kind of, if we're talking about noise specifically, is actually going to be very limited in respect of residents.
Any further questions? Any other? Councillor Sankey.
Thank you. Yeah, it's just about safety outside, because you said obviously if people are acting inappropriately inside, they would be removed from the premises. So it's what happens then. So perhaps a gentleman's, not behaving like a gentleman, he's escorted from the premises. What happens then? Because obviously if he may be in a state of arousal, he's out in the street, and we've talked about safety for women on the street as well. Thank you.
Every incident has to be dealt with on its own merit. So I need bit more clarity on what was the reason for the ejection, because if it was a serious matter, then the police and authorities would be called and they'd be dealt with accordingly.
Okay, thank you.
Any further questions? So I've just got a couple. So can you give us an idea of approximately how many customers are likely to go through the premises on an average evening? What sort of number of people? So it's the capacity of the venue, and then how many people you're likely to have pass through of an evening?
The capacity that we use is not the legal capacity of the venue, so we do not allow more than 180 customers in the building at any one time. And throughout the course of the evening, anywhere between 400 to 500 through the doors.
Thank you. So the only from going through the objections, the obvious things that were complained about the the operation. The only two I could see was the parking of the minibus and the moving of the bins. So the bins, I think, was objection number 1. What I was just going to say is there anything you could look to do to address those issues? I'm not sure they're appropriate things for us to condition, but is that something you can look to address?
In respect to the bins, there's a bin store now, so that's in place. As you'd be aware that the venue's undergone a refurbishment, so there's now a bin store to the rear of the venue. In respect of the minibus, that has a couple of specific pick-up and drop-off points. Am I right?
Yes, correct. There's one drop-off point which is on the road outside of the venue, and secondly, just off the roundabout. So at no stage is it parked there. It's only pick-up and drop-off.
And then final question, with the banners, which I'm just trying to find the drawing, are they put out each evening and taken in when it's finished? And would that be possible to minimise the visual impact of the banner that's shown outside of when the premises is operating? So, for example, if you're planning to start at 8 p.m. of a night, it could be put up at, say, 7:30 and taken down at whatever time in the morning it finishes. Is that possible or practical?
Yeah, it's possible, practical, and it will be done. We trade a coffee shop from 9 o'clock in the morning till 5 o'clock in the evening, so it'll have a completely different image, have a completely different market.
Okay, thank you. Are there any further questions from colleagues? Councillor Wheeler.
I'm not sure whether it's questions or where it should go. A little concerned about the hours. Would it be, because some of the hours you're starting at 6 o'clock, that does sound rather early to me. Would it be possible to have all your starting times at 8 o'clock?
Yeah, this has been brought up in previous meetings, and we've tried it, and it turned out we have a group of people standing outside the venue waiting for the venue to open, and it was decided at a previous hearing that 6 o'clock would be an acceptable time for the flow of people through the building rather than people congregating outside the venue.
So, are there any further questions? So, Councillor Barnes, so the questions have to come through the chair because there's no cross-examination. So if you can ask the question, and then we will see how that pans out.
Thank you, Chair. Yes, I will do. A lot of discussion has been about the internal organisation and aspects of the club. Not much has been mentioned about the outside activity. I know Councillor Sankey commented on it. I have to say, my concern might be more about the external side of the club, and I noticed that the applicant did mention SIA staff at the entrance. What powers do they have? What is their role in looking at people who come out of the club who have been aroused, their testosterone levels are high, their alcohol levels are high. Once they leave the club, what responsibility does the club have? And I have another question as well. There was comment made about staff going around the town, and I couldn't quite work out what they were doing going around the town. Were they promoting the club with leaflets and things? I just didn't understand that aspect of it. What was the purpose of that?
So I will give the applicant an opportunity to come back to some of those. But effectively, when we've looked at complaints about other licensed premises which have been made to the licensing team, as an example, there have been complaints of someone from a named venue using Imperial Lane for the purposes of urination. Now, Imperial Lane doesn't have a nightclub on it. It's out of the line of sight of the premises. So there is that. They are going to have a responsibility around the area, but I'm sure the applicant could explain how that works. In terms of the leafleting, which is a separately licensed activity, I think that is something where we've put some conditions on, but the leafleting, the licence to leaflet is granted separately, and I think officers can possibly explain that one.
Obviously, the council has taken a view on the distribution of leaflets in relation to these businesses before, because it's incorporated in its policy. It's incorporated it in its policy because it felt that it was something that would be appropriate to condition. So the council has conditioned that in the past, but equally the council has obviously heard from applicants and heard enough information to depart from that policy in the reasons given. And I think it's probably best for the applicant to explain why they distribute the leaflets, which is the question that was asked.
And I think if I now give the applicant the opportunity, so if you can explain the SIA protocol for your security staff and also about the leafleting, please.
So, on the standard conditions, standard condition 32, door supervisors shall regularly monitor the area immediately outside the premises for a distance of 30 metres in all directions and shall take steps to deal with, by alerting the police if appropriate, of any unsavoury activity that may be attracted to the vicinity. So there's that standard condition that is there as a safeguard, and that's a strict condition that they have to adhere to. In respect of the leaflets, we actually provided examples of these in our disclosures as 2 examples. It doesn't actually, we're not permitted to actually advertise the SCV venue itself. This is purely in respect of the courtesy bus that is available to customers to take them to and from the venue.
Thank you very much. So I'm just going to check where I am in this. So if there are any further questions from objectors, then again they need to come through the chair because there is no cross-examination in this process. So can I, if anyone's got any further questions? So, okay.
Start with the first one. It's interesting that we talk about the impact of the last race meeting. I wonder, did the council do a survey? Did the venue do a survey of the residents in the area or people around to find out what that impact actually was?
if you would like to, yeah, I mean, I can't answer what the council did. I know that councillors and licensing would have been out, but licensing would have been out every night. The police would have been out every night, as the authorities.
So it wasn't to do with who was inspecting them. There was a lot said about the attitude of the people in the area to the venue and what happened in the venue. I'm just wondering where that information came from, because it's not clear.
I'm not sure
Don't know what information that is.
Yeah, I'm not sure what information that is.
So you in your statement said that the SEV had no real impact on the area.
So we need to be. So I need to be careful because we're not allowed cross-examination. So the council would respond to any formal complaints made to licensing about licensing conditions or environmental health or any other enforcement part of the council.
Sorry, the question was particularly to do with impact on the area, because that's the point was being made, and so that is not an issue to do with the licensing application. That's to do with the residents and the attitude of residents in the area and the people who walk through the area and the folk who drop their kids off at dancing class, etc. How would you know what the impact was? Because that's what was being talked about.
And ultimately, that's from, I would say, complaints into the council would be one method, which would be the documented way. It would be complaints to the police. Those would be the sort of
So you're saying that nothing was done to find out the reality of the situation?
I'll let the applicant's solicitor come back.
Fundamentally, there's no obligation for the applicant to do so. Part of the renewal process is defined by the Act. We're under no obligation to have surveys in respect of impact on locality. However, by having the robust conditions in place about how the venue looks, how the venue operates, what numbers of SIA door staff they have, how those SIA door staff members have to safeguard that area, that 30-metre area, and I could go on about all the other types of conditions, you're going to have far less impact on the locality than if you just rely on an exemption.
As far as the impact whilst the event was going on, I was in the local area. I stand outside the front every night in the pouring rain, and I remember having long conversations with your congregation, very friendly and very chatty, and at no stage was nobody was complaining. Everyone was quite happy with it, and then, to be honest, there wasn't a lot of passing footfall through the area at all, because I was there all night.
I'll let you come back with some more questions.
Yeah, so the next question is very simple, which was how many days in total is the new application for? Because that was kind of skipped over compared to where we are now.
I think it was 17, if you include the into the following morning.
So we just need to know that, because we're talking about 72 days out of 365. Are we? Is that, sorry, did you say 72?
17.
17 for all the race meetings.
That's what I think it is
in total.
That's what I made it. If you count the day as as a 24-hour period. So if you start at 6 p.m. or 8 p.m. and you carry on until 5 a.m. If I count that as one day, I think it was 17 days in total. But if you're going to add the bits at 5 in the morning, it will be a little bit more. That was what I calculated.
Okay, thank you. That's really, really helpful. Thank you. Sorry.
Could I ask a question, if that would be okay? Just regarding the opening hours and the comments, I think that also were made last year regarding groups of men gathering outside of the venue if we stick to 8 o'clock. Am I right to understand that whilst there are groups of men outside, I mean, we have Taylor's that does have an outside area, is there any evidence from the police that the gathering of groups of men outside on the pavement in Cambray Place has led to any increase in antisocial behaviour or an increase in crime? I'm struggling a little bit to understand what the problem with groups of men outside is and why that has an impact on opening hours.
So the police have made no representations this time. I believe previously they have suggested it would be preferable to have people inside venues rather than hanging around outside. But I'll let the applicant's solicitor come back on that as well.
Yeah, that's correct. Also, it's not just groups of men. I just want to make that very clear. We have men, women's, couples. I just want to make that clear, though. And it's a way of having that flow through the venue during those hours, and it's worked very, very well. Worked very well during the busiest part of the calendar, which is March Race Week.
Might I just comment that I am actually referencing meeting notes, so I'm not making up. I'm referencing incidents of groups of men gathering. They're minutes from the council's website. So again, I'm just accessing information that's publicly available. But again, I'm struggling to understand what the problem in relation to opening hours is regarding groups of men. There are lots of venues in Cheltenham where groups of folk stand outside. I don't really understand why groups of men standing outside, or women outside of this particular venue, needs to result, whether it's a preference or not. There's no direct evidence of any antisocial behaviour or crime that I would suggest means that this venue has to operate outside of the standard conditions within the council's SEV policy.
That sounded like a statement rather than a question.
Do you agree? Question mark.
I think, the applicant is entitled to apply for what they want. The committee needs to weigh that and weigh the evidence that we may be aware of from the past, what the applicant says, what other people, what objectors say. So I think it's up to us to weigh the pros and cons. You can look at large gatherings of people outside venues as a safety risk. You only need to look at issues outside Brixton Academy in London, where that was obviously mismanaged in other ways, but there are sometimes preferences for having people inside the venue in a managed way. I'll let the applicant's solicitor come back.
Yeah, I would agree with that, and it's almost a bit of a case of damned if you do, damned if you don't, because if we did have people outside, then we would have complaints of people queuing outside. The fact that we don't is because of these operating hours that we've applied for, and it's not a standard set of hours. We have thought about it. You can see from the hours that have been applied for, with the years and years of experience that this operator has, they know what works, and we know it works because when people come and inspect, be that from the police or the council, there are no issues.
Thank you. I'll let you carry on.
Thank you. Chair, I just wonder if it was possible that they can explain, given that the designated permitted area runs immediately along the railings and the steps of the building, the degree to what they need to, that they actually use the non-designated permitted area outside.
I'll let you come straight back with that. I think we tried to cover that in the questions to the licensing officer at the start.
Yeah, the designated permitted area is in reference to the licensable activity, which is the licensable activity being the relevant entertainment. You're not having relevant entertainment taking place outside of the designated permitted area.
But then the movement of individuals from within a designated permitted area on the high street down into the building itself, guided by people from within the establishment, which did happen, Steve, so you can't say it didn't, is therefore somehow not part of the activity.
The activity is the relevant entertainment, and the relevant entertainment is that which is provided for within the designated permitted area.
Yeah, so the law is what we are licensing is within the red lines on the map within the premises, which, based on the map in the policy, is within the area. That's how I would interpret the law, and I think if we were misinterpreting the law, one of the very learned professionals either side of me would be telling me that we were wrong, as would the applicant solicitor.
Yeah, so I was really questioning on the claim of minimal impact, really, because people obviously wouldn't be coming to us going, they're not going to send their children anymore to our activities. if the impact had been minimal, if it was not visible, would they?
I'll let you come back to that if you have a response.
That can be on perception as well as anything else. And like I said, I've looked at the meetings and where they take place and when they take place, and it's not on the Cambray Place entrance, it's the Rodney Road entrance. And I think at the last meeting when the licence was granted, it was said that the Rodney Hall, Rodney Road entrance was the most used entrance during the evenings.
Right. Are there any further questions?
No, I was only going to answer that, but yes, the Rodney Hall entrance is the most used entrance in the evenings, but people perceive an area by what's in the area, don't they? And we've seen that effect in other cities as well.
I'm not sure that there is a perception. I think there is probably a perception for people standing outside about what is or is not going on that may be from... it's not the same as what we see from going in and accompanying the licensing officers. There may be a perception, and I think that's the problem. There is a perception and a stigma.
You can't see the relevant entertainment from the exterior of the venue. And again, I come back to the point that this venue is highly regulated. There's unfettered access to responsible authorities to come and visit this venue. The operator is always working, you know, to be as open and transparent about its business. If there were any worries about impact on the locality, I'm sure we would have heard from the police and the council at the debrief that happens after every event.
The other point which I'll make just from the licensing conditions which apply is there is a condition which I can't remember which number or the exact wording, but it says effectively scantily clad performers shall not be visible through the entrance to the premises, and if you operate under the exemption, that no longer applies from that perspective.
Sorry, I'll just say to the venue operators that they need to check their top floor then. This is meant to be a proceeding where we which is managed. There isn't cross-examination. Just get to where I am. So I think we now go to. So we've got a new constitution, and I'm just trying to make sure I go through things in the right order. Right. So we've heard from the objectors and any of the questions there. What it says, with some odd indent, is a final right of reply. I don't know if one of you would like to sum up on behalf of the objectors. I'm not going to sum up, but just to say we are not organised together as objectors. Clearly we could be, and clearly in the future that might be the case, but we don't operate that way at the moment because we wanted you to hear the views of individuals, and we have not garnered additional we've not created a movement, if you like. Could happen, but it's not at the moment.
I think it is fair to say that we weren't aware of this opportunity until we arrived for the meeting this evening, so we're slightly caught off balance with that.
So this is just the constitution that was voted on at council. So it is, if we go through, if you all have your final right of reply, and then the applicant has their final right of reply. So if there's anything else you wish to say based on what you've heard, that's your opportunity. Councillor Dobie.
It's been mentioned that there was no resident survey or any survey post-event in the past. I'm just wondering whether you as a committee could maybe make a recommendation to the council or council officers that might take place.
I think that possibly is beyond our powers. I don't know for sure.
I think given that obviously there's a cost implication to doing something like that, that would be done by a different part of the council and there'd have to be proper justification for that to be done. If that was something that was determined elsewhere in the council, then so be it, but it's not for this committee to decide for the council to spend money in that way. I think it has to consider the application as it's been made and it has to determine it accordingly. And if the council elsewhere sees fit to carry out something like that, then, but I'm not really sure how that would be targeted in a way that's relevant to this hearing. And obviously the council is already doing a survey that's related to these issues.
So to come back, obviously you are a cabinet member. I'm sure you can talk to your cabinet colleague for communities and safety, Councillor Clucas, and look at how that would fit into the budget protocol. That may well be more appropriate than using this to try and condition something that we probably can't do and isn't within the licensing budget. So are there any other final rights of reply from the objectors who wish to say anything further?
So just a point of fact, please. With reference to reports to the police of any sexual harassment or incidents, statistically we know that 4 out of 5 women will not report to the police anyway. So I think we just need to bear that in mind and not always assume that no reporting to the police means that nothing's happened. And also we tend to find that people, when they do report, it's not straight away, it's some time after. And my other is a question, I suppose, which I might be a little late for, but if we're concerned about the operating hours and not starting till 8 o'clock rather than 6 o'clock start, if the venue is used for afternoon tea, etc., during the rest of the day, is there no reason why people would have to loiter outside on the pavement? They could go into the building, they just won't be seeing the sexual entertainment acts.
I'm not sure I can answer that, but I think we now need to move to the applicant's final right of reply. So if you wish to address that, feel free, and then we will move to the committee. What it says is retire to debate the application. I'm going to suggest that we try and do it in public so that people can hear what we have to say, if that's acceptable to the rest of my colleagues. So, applicant solicitor.
So I'm going to keep my summing up relatively brief. The change from how the venue operates in the daytime into the early evening would mean a period of time where they would have to adjust the setup. So I don't think that necessarily works in respect of the hours that we were just discussing. I'm not too sure I quite understood the point. But in respect of my summing up, again, I just come back down to the fact that this is a highly regulated area. There are, I think it's 40 conditions on the SEV licence that have to be complied with at all times. That is in addition to the conditions that are required under the Licensing Act 2003. The applicant is known. The applicant is known and it has a proven track record of successful operation within Cheltenham, not just at this venue, but at other venues as well. The police have not made any objection to this application. I really do think that is key, because if there are any concerns in respect of performer welfare, customer welfare, welfare of women, we would be hearing from them on those points. I also think the exemption point is a really important one. If operators are completely permitted to operate under the exemption, but the issue with that is, from a regulation perspective, is you don't have anything like the number of conditions, you don't have anything like the number of able just to be able to go and visit and know when a business is operating, know how they're operating, go in and inspect. It makes it much more challenging for local authorities. And I think that by granting the license, granting the renewal of the license with the varied condition 6, with the varied hours, is the optimum position, because you know that by virtue of the conditions, by virtue of inspections, that this is going to be a safe and well organised premises.
Thank you very much. Right, so we now need to move on to the member discussion. So, members, before we move to the debate, I will remind you it is important that you give due regard to the Council's licensing policy, and if you deviate from that policy, you give clear reasons for doing so. It's also important that you only take into account material licensing considerations and that your decisions are reasonable, proportionate and rational. I don't know who wants to start. Councillor Seacombe.
Thank you very much. In one of the previous premises that this company used, the Two Pigs, I've made 2 visits there, once in daytime to see the facilities that were being offered to the participants in the evening entertainment, and on another occasion during the evening to see how the entertainment worked. And I found it singularly tedious, actually, myself, to be honest. However, that's a personal feeling. The premises are well run. They have a very a good and efficient system of wristbands and no cash and all that sort of thing for the participants. And I can corroborate what has been said by their solicitor, that it is well organised and the safety of the performers is paramount. As far as people worried about what is going on behind closed doors, which effectively is what it is, you could walk down the high street, you could walk past Marks and Spencer's, and there are a couple of small premises there. You don't know what's going on upstairs in those buildings. There could be other, they're not, because we haven't licensed them, but does it matter at the end of the day? And I say that with reference to people who are worried about how it would affect churchgoers and also particularly children. The hours that they operate don't really affect, it depends what you call a child, of course, whether someone who's 14 is rather different from someone who's 7 or 8. But that brings me to another point that I'm going to make. But to my mind, it doesn't really affect, even though it is that close to the church, it doesn't affect people going to the church. And my downsides, I mean, I've said things at the moment, just now, which appear to be promoting the licence application. My downside is, and it has been brought up by other people tonight, is the noise that could be generated as people, enter, as they're queuing up to enter. And we've heard why we start at 6 o'clock on some days in the week, and not every day. That's interesting that some days they can start at 8, but not on others. And the noise generated by those queuing up and coming out, certainly late at night until 5 in the morning, could be considered, although we've heard no reaction to that, could be considered a nuisance. And I would still go with changing the time of entry on those 5 days in the March meeting to 8 o'clock, which would help those who are worried about what they might see. In my estimation, nothing. And I have stood outside, not something run by this company, but another one, and watched people going in. And there was, they were going in ones and twos. And I stayed there for quite some time. So I would have no hesitation in allowing this licence for most of the reasons that I have just mentioned. Thank you.
Thank you, Councillor Seacombe. Shall I take Councillor Wheeler first? There you go.
I was going to say ladies first. Yeah, well, I can't remember where I was going to come in here. We've got a choice here between a legal way forward, a licensed way forward, not legal, or somewhat unlicensed system. if this government or any future government decided to make sexual entertainment illegal and banned it, you know, I've got to be quite honest, I wouldn't be raising too many questions. I don't think I'd be raising any questions. It's not something that appeals to me. Having said that, sexual entertainment is a legal business. And until such times as it's made illegal, we have to deal with what's in front of us. We can do it in one of two ways. Well, I guess three ways. We can either license with, I believe it's 40 plus conditions that take care of performers, staff, customers and members of the public, covers all of those. Or we can say you can use the exemption and do it with few, if any, conditions, and we can do little about it. Or, as I say, if we go back to, you know, perhaps a future government making sexual entertainment illegal, well, we all know what happened in America when, in the times of Prohibition. It didn't stop people from drinking alcohol. In fact, it made it a lot worse because they were drinking illegal alcohol, which was poisonous and it was killing people. And I know it might sound very dramatic, but I think perhaps that's what we would get if sexual entertainment was banned and made illegal. I have had people tell me that they know of places where sexual entertainment was going ahead with no, totally illegal in back rooms and the stuff. We do not want that. If we've got a well-run operation that's controlled by, I believe, good operators, from all I've heard, it's covered by council officers, it's covered by police. We can do pretty well everything that's possible to make it run correctly for the majority of people. I personally think that that's a better way forward than trying to find some other way forward. If someone can suggest a better way forward to me, I'm certainly prepared to listen. But from all I've seen, this agreeing to this application seems the best way forward to me.
Thank you. Councillor Boyce.
Thank you, Chair. I agree with the comments that my colleagues have made this evening so far. Just for the purposes of the minutes and ensuring that we cover off and everything, I'll add a few things myself. Parliament has made it lawful to operate a sex establishment, and that such businesses are a legitimate part of the retail and leisure industries, and we have to remember that. It's our role to administer the regime in accordance with the law. In our determination, grounds for refusing a licence, we have to look at the mandatory and discretionary grounds for refusal. As I've already asked of the officer, are there any mandatory reasons why we'd refuse this? There are none. And then if we go through the discretionary grounds for refusal, the officer covered off on most of them, except we have to, I'll come back to in a minute, the grounds under locality. We have to have duty, we have a duty to regard any observations by the police, and as has been covered off on already, the police haven't raised any concerns or objected to the application. With regards to the locality, well, we have licensed this before. We've had, this has come to committee before, and we have licensed this before. And as I asked the officer, well, have there been any complaints about this license previously with the same applicant? No, there haven't been, and there have been no complaints from the police. Public safety is our paramount concern. So we all, again, my colleagues have already covered this, but it is so important to highlight, do we want licensed activity or unlicensed activity taking place? The conditions, I have visited venues run by the applicant during race week, I have spoken to performers there. I have no reason to doubt that it's a very well-run establishment. It's very, very safe in terms of what's happening inside. They have all the guidelines. We have spoken to the performers in great detail, and they're happy to work there. And so in terms of public safety, I would absolutely always prefer this activity to be licensed, because ultimately it protects the performers, it protects the customers, and it protects the general public. In fact, on one occasion when we visited during race week, I think it was the chaplain from the racecourse was there offering support and handing out cake. It was all, you know, there was a lot of support there, and it was clearly very well run. So in terms of the locality, I think that obviously we have licensed this before. Nothing has changed. I've been on the website to look at when the activities take place at the church, and I believe that the Rodney Road entrance is used for the youth groups, and I don't see any other crossovers really at all with regards to when activities taking place in the church and the license, the hours that they have applied to be licensed for. So I am minded to support this application, and I hope I've clearly laid out why.
Thank you. Councillor Sankey.
Thank you, Chair. I support the comments made by my colleagues, and I think, as everyone has already said, regulation is crucial for everybody's safety. So I think it is really important that we do regulate this. It's not done through exemptions. And equally, as was also mentioned about the 6 o'clock start, that does feel a little bit early for some things. Things like, I know there's a nursery nearby and shops. Shuts at 6. Yeah, but if you're opening at 6, it's that sort of crossover. I think that was my only sort of concern. Yeah, okay. But that was my only sort of concern with that sort of timing. Okay. But other than that, yeah, I'm minded to support it, because I think it's really important it's regulated. Thank you.
Councillor Wheeler.
Yes, just very quickly, there was comments made about have we surveyed the area, and I'm very much with the officers on that. But if we're going to survey the local area regarding an SCV, should we also be surveying people, clubs, pubs, and just about every other business that runs at night? Because I think, you know, why do we treat one organisation differently?
Thank you. So going through from the reasons that I've picked out, the obvious reasons that, or within the law, the only things that apply are discretionary grounds D1 and D2. We visited the premises. We're satisfied with the internals of the premises from the visit. So going through it, the applicants complied with the rules regarding consultation. That's noted at 3.5 and 3.6. The council's gone beyond the minimum statutory consultation requirements, so it's included the bid and GRASAC. The Chief Officer of Police has not raised any objections, which is material at 3.9 in the report. If you look at the quantum, and obviously that's looking at the numbers, not the quality of the objections, and actually the quality is more important, then we've had 36 objections and 50 representations in support, which for a town of approximately 120,000 people is very, very small. I think it's 0.03% of the population, and that assumes that everyone making representations lives in Cheltenham. The legal principles of reasonableness and proportionality are engaged, so we've permitted the premises to operate for 5 days during 2023, earlier in race week. This is long since passed, and any issues identified by the police or licensing enforcement or any other enforcement part of the council, other enforcement authorities would have or should have come to light now. And the absence of that evidence is also material. We can't, if there's no evidence, it would be somewhat irrational to refuse. The variation, as I calculate it, looks to go for 17 days in the year, which means for 349, because it's a leap year, there's no licensable activity going on. I think that from what I said, there were complaints about where the bins were. We've raised that the bins are in a bin store, and it would be wholly unreasonable and disproportionate to with refuse based on parking matters. In terms of public sector equality duty, which we have to give due regard to and show that we've given due regard to. So the licence is silent as to the sex of the performer, the sexual preference of the audience, and any gender reassignment of either of those parties. The council has to apply the policy in a way that is equal, irrespective of how the licence is used. So it's been cited the public sector equality duty on women in the town. It's also engaged on the grounds of religion or belief. But at the venue in question, the performers are all female. Sorry, we're in the debate now, so we can't take any further representations.
It's just an inaccurate thing you said, that's all.
What is supposedly inaccurate?
Sorry. You mentioned the numbers of proposed of supporting and objecting. Of course, you didn't mention that the number of duplicates in the support, but also the fact that on the notice that went up in the window was printed on black on blue with no email on it, which is, as Jason will tell you, is why they got a lot of letters from people. So there wasn't the normal way of responding to the notice that was on the window. I've got a picture of it. You'll see afterwards. So and it's just you quoted those numbers in support.
I quoted the numbers. Saying that that's... I didn't quote the quality. I said that was the numbers. So that's what was in the report.
If people haven't got an ability to respond,
sorry,
that's
I'm not going to have a debate with the point for debate is over. The council cannot. Where were we? So the performers are all female. The activity is lawful. Licensing exists to make it safe or safer, and as a licensable activity with enforceable conditions, it's likely to be safer than activity occurring under the exemption. The council cannot take a moral stance on the activity. We're therefore presented with a group of people with the protected characteristic of sex, arguing that they should deny a group of people with the same protected characteristic of sex from engaging in a lawful activity. In terms of religion and belief, the other licensable activities are often incompatible with some religious beliefs. So this includes the consumption of alcohol. It may well include gambling as well as sexual entertainment. So we are trying to apply the principles of the public sector equality duty set by the courts of making due regard. So we've been informed by the officers about the public sector equality duty, we've been informed by the objectors, and we've been informed by the applicant of that with reference to the Journal of Licensing, which I think I actually have in front of me, that article. We've considered it from the outset. The policy documents are silent on the sex or gender reassignment of performers and the sexual orientation of audience. The policy will apply equally to this venue as it would to male performers such as the Dream Boys or a premises serving the LGBTQ+ community. So the the council has to comply with the statute. So we have to prevent people from under 18. The council has sought to apply a Challenge 25 policy. So that is we are not allowed to take moral objections into account, and that is Newcastle upon Tyne, R versus Newcastle upon Tyne ex parte the Christian Institute. That is why we cannot take into account objections on moral grounds. If that wasn't the case, then those with objections to licensable activities, which could include, as I said, the sale of alcohol or gambling, they could all be blocked on religious grounds. And Parliament has legislated to make this a lawful activity. We've given due regard to the sensitivities in a way that doesn't look at the just the physical vicinity, but also the temporal vicinity. So activities where the premises adjacent or accessed from, which is Rodney Road, not Cambray Place, as well as possible consideration of whether the time should be later, which is something I think committee needs to decide on. So we've got female performers, female staff, women who want to go about their normal daily life in the vicinity of the premises or the town as a whole. So we've got three, possibly more competing groups. In weighing the representations, we need to consider whether the number of extra nights or the number of nights that it will operate from is going to have a material and discriminatory effect suggested by the objectors. Given what we heard from the applicant, that I think we're looking at 400 to 500 people visiting per night, when the races attract something like 65,000 people, of which, let's say, 10 or 20,000 coming to town. It would seem unreasonable to hold the SEV responsible for the ills claimed during race week. We've looked at the licence condition. The licensing condition says the applicant really is only responsible for 30 metres around the premises. We also need to think about the safety of people operating under the exemption. We're told that this could discriminate against women in town, but if we refuse it, we could be discriminating against female performers on the basis of their sex by making it less safe for them to work. So we weigh that decision in reaching the conclusion. There's a comment about public safety. Cambray Place is wide. As far as I'm aware, it's well lit. You can, there are easy ways round that don't require walking past the premises if you don't wish to, that are probably no longer. So my conclusion, I think, is that I think licensing is the way forward. I think we've considered our public sector equality duty. Just wanted to find a quote from one of the supporters, and it's the last sentence of the last paragraph of the last representation, and it just says, "If this entertainment is going to happen, I'd much rather see it licensed, inspected and monitored for the protection of everyone involved." I think that is a very good summary of my view on that. If you'll excuse me a second, I've been talking and I need to get some drink. So I think the question for us is whether there's whether we wish to vary the hours. I also think it would be useful to potentially condition that the banners are not there sort of until an hour before and removed an hour after the activity finishes, to try and mitigate some of the potential sensitivity so they are not there during the day. Councillor Wheeler.
I do wonder whether an hour is rather a long time, because if we've got a 6 o'clock start and the banners are up at 5 o'clock when children are coming, I would have suggested that quarter of an hour, 20 minutes was quite ample prior to the start of business to put those up and take them down.
I'm happy with something like we've got to specify a time so that the condition is measurable and what have you. It also has to be proportionate. So if you, yeah, I mean it might, yeah. I was going to suggest that if we can ask the applicant how long that might take, and then we can try and condition that, and then I'll bring in Councillor Seacombe.
If the operation was starting at 6 o'clock, then yeah, I think, how long would you need? 15, 20 minutes?
Yep, we could do that.
Yeah.
Okay, so if we're happy with a condition that they should be taken down, we probably, let's provide some leeway and say 20 minutes, that I think, if people are happy with that. And then Councillor Seacombe.
Yes, I think if I'd had my question in before, or my suggestion, then that would have linked in with the timings. Are we going to consider an 8 o'clock start in the those 5 days which are down to 6? I know that my colleague over the way was contemplating that as well.
Yes, I think we are. I think we just needed to get to the go through the reasons, because it looks like there's a unanimity that we are happy to grant. There might not be unanimity on the hours. Councillor Boyes.
Well, it's just coming back really to what the applicant and the applicant's solicitor mentioned, in that do we need lots of people waiting outside, but would they be waiting outside? Maybe I think we need clarification, because obviously the objector also mentioned that if it's open anyway, they can go in anyway. So are we just talking about so obviously we're just talking about the licensed hours, but they're going to be going in anyway because it's already open. I think just need to clarify.
I think there will be some set-up time, but I think it's best we ask the applicant to clarify that.
Yes, there'll be set-up time to convert it from its daytime operation to its nighttime operation. If I'd left it set up to its nighttime operation, it'd be different for that.
Obviously, bearing in mind that when it traded in March of this year, the 6 p.m. was there because of getting that flow of people, so they're actually inside the venue as opposed to waiting outside, and that's why those timings have been carefully calculated for those specific days of that race week, because you're thinking about the numbers of people that are coming through the town. So yeah, you need that set-up time, so people couldn't just go in there anyway as the SEV venue, because you've got that changeover from the cafe operation to the SEV. And at the same time, you've got that 6 p.m. there, which is a tried and tested method of making sure that people are just coming into the venue, and then we're not having that queue of people outside.
And reverting back to the 6 p.m. was a recommendation by the police, and we discussed it with the council. It's crime disorder.
I mean, looking at the dates on page 90, 93, 94, the only ones that are 6 p.m. starts are the Tuesday, Wednesday, Thursday and Friday during March. The rest are 8 p.m. So I get... My personal view is I think the applicant has used those before. I'm not minded to vary, but others may have a different view. Councillor Boyes, then Councillor Wheeler.
Thanks. Thank you, Chair. Yeah, I'm of the same opinion as you. I'm of the same opinion as you. If it works before and the police have suggested that, then I would be happy to go with that and not actually vary from what they've actually put in their application.
Councillor Wheeler.
Yes, I think I'm along the same lines, and I'm just thinking if I mean, they're saying they don't want queues outside, and that sounds quite reasonable. It was suggested that perhaps they could be allowed in at 6, but sexual entertainment doesn't start till 8. Well, quite frankly, how will anyone outside know whether the sexual entertainment has started whether they come in at 6 or whether they start at 8. So I can see no real reason, and I do accept the argument the applicants made.
So I think, oh, Councillor Sankey.
No, it's just to say, you know, having everything been explained, yeah, I'm quite happy with that. Thank you.
So I think we are at a point of reasonable consensus. So I now need to look to licensing officer to check. Sorry. So just, sorry, I was just taking some legal advice. Do you still object? Do you still want the movement to 8 p.m. for those 4 days, or are you more with the consensus?
If you had a vote, it would be 4-1, so I don't think I could have any grounds for resisting your decision.
Does that clarify for the minutes?
That does, I've got it.
Okay. So I just need to check with licensing officer and legal officer that you're happy that you've heard sufficient for our reasons, that we've gone through and covered everything.
Thank you, Chair. I just think you need to obviously have ensured that you've gone through certain things specifically and you've made a decision on certain points. Obviously, the number of days in its own right and the totality of those days, if you're going to be determining the application on the basis of all of those days, then you will obviously be making that clear. If you are going to be determining it on the basis of less days, you need to be making that clear. You've kind of seemed to have covered off the hours issue, but you obviously need to be crystal clear on whether you are granting the application as per made by the applicant in terms of the hours. You also obviously need to be confirming whether you agree to the continued variation of the leafleting condition, which was referred to, because obviously that's a departure from policy which is on the current licence, but you do need to be making sure that if you've specifically considered that point and whether you are going to be allowing that to continue, and obviously to agree any additional conditions that you think are necessary for the decision that you're making. Thank you.
So I think from where I was at, which I think hopefully people will reach the consensus, it was going to be to add the condition that the banner should be up no more than 20 minutes before regulated entertainment is licensed to start and removed 20 minutes afterwards. Other than that, I think my view is I was happy with the application as made. I'm seeing nods. Does that cover off?
It was just to make sure, as I said, that particularly in the last point about the variation of the conditions, it's sometimes very easy to get carried away by the debate about everything else without absolutely nailing everything nice and crystal clear. So it's just for that clarity for everyone of what has been agreed, what will be agreed.
Yeah, I think it's the only difference from what was applied for is that the condition about removing the banner. I'm not seeing any dissent from that. Are you happy that you've got those? Right. So, in theory, we now move to the vote. Are we all happy for that? A show of hands. So that's unanimous. So the licence has been granted. We've added the condition about the banner, and there should be a decision notice issued in due course. Thank you very much. And there's no other items that are urgent and require a decision. So at 8:10, I declare the meeting closed. Thank you.